Well, hello and good morning and welcome to this St Philip's Chambers webinar. This is an employment team webinar on non-employment discrimination claims, law and practice. It's great to have so many people signed up. Thank you very much for joining us. My name's Colin Barron. To my right this morning, I've got Tamsin Sanderford presenting, and to my left, Patrick Keith. As I mentioned, we're speaking to you on non-employment discrimination claims this morning. Might seem a slightly odd topic for the employment group to talk to you on, but the expertise that we have here in discrimination law is the common thread that runs through this area and our practice. And we also have significant experience in litigating matters in the civil courts, which we can bring to bear when these sort of matters come to us. This is a growing area. We're increasingly being instructed to assist with cases across many different areas in many different sectors where there is an Equality Act claim or dimension to the issues involved. Sometimes they're part of a compendium claim, the kitchen sink claims we sometimes see in tribunal matters are replicated in the county court, where you have personal injury, breach of contract, breach of confidence and data protection type claims existing alongside a claim in relation to the Equality Act. Sometimes you have freestanding claims, provision of services, a particularly hot topic at the moment. For example, access to single-sex facilities is probably going to be an area against the increasing amounts of litigation in the county courts, engaging with Equality Act principles. Sometimes we see these cases as defences to proceedings, for example, in possession-type claims, defences based upon disability discrimination. So what we're hoping to do this morning is to showcase to you our expertise in discrimination law and how we can help you to bring and defend claims in the county court. On the agenda this morning, we've got three short sections of the presentation before questions at the end. It's been great to see so many people sign up, but as a consequence of that, we've got a broad range of different specialisms in our audience today. We've got people here who come to this from an employment law background, used to litigating in the tribunal. We have those who are county court commercial litigators who want to know how Equality Act claims differ and the nuances that we have there. So hopefully we've got something on the agenda for everyone, but it does mean we're going to have to start with the basics to flesh out discrimination for those who aren't dealing with this day in, day out. So the way we're going to take this today is that Tamsin's going to give you a short primer in terms of the Equality Act discrimination generally, before Patrick will then take you on to consider the particular areas of non-employment discrimination that the Act covers and how they will differ from employment claims under the Equality Act. Then finally, I'll pick up with a perspective from the county court litigation area. I will introduce the differences that a county court litigator will see when dealing with an Equality Act claim, and also point out to those of you more familiar with tribunal proceedings how things will differ when you're handling a county court claim. So, as I say, I hope you find something of use here. For time for questions at the end. As we go along, if you have any questions, please put them in the chat. We won't be able to deal with them as we go along, but we'll have a look at the end and see if we can help with any of the queries that arise as we go along. That's all from me to start with. Without further ado, I'll hand over to Tamsin to take you through some Equality Act discrimination.
Thank you very much for that introduction, Colin. As Colin said, for those of you who don't deal with the Equality Act day in, day out, we're going to start with the very basics, which are the 9 protected characteristics. So these are the only things against which discrimination is prohibited by the Equality Act. Sex, of course, the last one on that list, is something of a hot topic at the moment with the Supreme Court's decision in For Women Scotland Limited and Scottish Ministers, which established that sex means biological sex. We certainly don't have time to get into that, but it's something to flag. That there are areas where definitions are not necessarily as obvious as they may seem. For non-employment cases, Part 3, services and public functions, does not apply to age so far as it relates to the under 18s. It also does not apply to marriage or civil partnership. So that is the first difference that I wanted to flag for those of us used to dealing with employment cases. So starting with the first type of discrimination, which is direct discrimination. This is possibly the easiest to understand and reflects what we tend to think of as discrimination in a day-to-day sense. So in a simple explanation is that direct discrimination is where an individual is treated less favourably than another individual because they have a protected characteristic. Now, when we talk about another individual doing that first step of a comparison exercise, whether someone was less favourably treated than another, we can have either an actual comparator or a hypothetical one. So either a real individual that the claimant can point to and say that this person was treated better, or failing that, a hypothetical comparator, which is how the service provider or the provider of a public function would have treated an individual without the protected characteristic in materially the same circumstances. So it won't necessarily be a real individual. Direct discrimination includes discrimination by association. So, for example, not a disabled person themselves, but they have a disabled family member. It also includes a perception of a protected characteristic. So, for example, someone that is perceived as being homosexual, even if they are not, they could have a claim of direct discrimination if they're treated less favourably because they're perceived as having that protected characteristic. And when we're talking about race, segregation will automatically be an example of less favourable treatment. Though, of course, we still have the other elements to think about when we think about the other protected characteristics. Age discrimination is an interesting one. As I've already said, it doesn't apply under Part 3 to under 18s, but it can also be justified as a proportionate means of achieving a legitimate aim, which is unusual because usually direct discrimination is not justifiable under the Equality Act. There are also some caveats contained within Section 13 itself. For example, it is not discriminatory to treat a disabled person more favourably than a non-disabled person. So you can't have that claim the other way around, a non-disabled person making that claim that someone with a disability has been treated better. And for the case of marriage and civil partnership, the individual themselves has to be married or a civil partner. They can't say that they're associated with someone who is married or a civil partner. And where the individual bringing the claim is a man, no account is taken of any special treatment given to women connected with pregnancy, childbirth or maternity. So, for example, breastfeeding might come under that, but that wouldn't count if the individual is a man as direct discrimination. The next kind of discrimination is indirect discrimination. So this is where there is a policy which applies to everyone in the same way, but it would put those in a protected group at a particular disadvantage. So in these circumstances, the relevant protected characteristics does not include pregnancy and maternity. But indirect discrimination does include where the policy, which we refer to as a PCP, a provision, criterion or practice, would put the person at a disadvantage if it were applied. So, for example, the individual bringing the claim did not actually take up the service because they were deterred from doing so. The fact that the policy was not actually applied to them in those circumstances would not preclude the claim because the indirect discrimination provision does include where the policy would put the individual at a disadvantage. So, for example, thinking about services, say, for example, a Jewish person decided not to apply to a particular university because they exclusively interview on a Saturday. Jewish people, of course, having Saturday as their Sabbath day, they might be deterred from applying for that service. So even though the policy of applications only happening on a Saturday applies to everyone across the board, it would put Jewish people at a particular disadvantage in this example. So you might have a claim of indirect discrimination there. Harassment is another kind of discrimination. In this type of discrimination, the relevant protected characteristics again excludes pregnancy and maternity, and it also excludes marriage and civil partnership. The simplest form to understand is where an individual is subjected to unwanted conduct related to their protected characteristics. So you can understand that's a bit broader than direct discrimination, where it's because of a protected characteristic. For harassment, it only has to be related. It then has to have either the purpose or the effect explained in section 26, subsection 2. And that's quite a wordy section, so I haven't repeated it here. But essentially, it's the creation of a hostile environment or the cause of offence or intimidation. There is a caveat to that, which is where it is not reasonable in the circumstances for the conduct to have the effect that the claimant describes, the tribunal or the court takes it that it did not have that effect, even though quite often it in fact did. There are also some provisions under section 26 related to sexual harassment. So subsection 2 relates to unwanted conduct which is of a sexual nature and which has the prohibited effect. And subsection 3 relates to where an individual is treated less favourably because of their either rejection of or submission to that unwanted conduct of a sexual nature. That is going slightly off on a tangent, so I haven't gone into it too much, but I include it there just for your information. The interesting thing about non-employment discrimination is that the prohibition on harassment excludes sexual orientation and religion or belief. And I know that Patrick is going to talk to you a little bit about one of those cases, so I'll move on for now. We also have victimisation, and this is something that is specifically laid out under Part 3 of the Equality Act in relation to provision of services. Victimisation is where an individual is subjected to a detriment because they have done a protected act. So a protected act is often making an allegation that there has been a breach of the Equality Act. So if someone were to write a complaint that they have been discriminated against by, say, a restaurant, if they were then subjected to a detriment by being barred from the service, that could well be a good claim of victimisation. And specific to non-employment situations, the prohibition on victimisation covers not providing the service, changing the terms of the provision of that service, terminating the provision of the service, or any other detriment done because the individual has done a protected act. And that applies, as I say, to services, but also to the exercise of a public function, which is not the provision of a service. That's a relatively narrow situation. But public functions might, for example, include the emergency services.
Although Tamsin, in terms of cases that I've dealt with in relation to clubs and associations, victimisation is often a useful avenue to pursue because you don't have to prove that the original complaint was actually valid or was discriminatory, or the discrimination complaint actually happened. I've seen cases where clubs have excluded people because they threatened claims under the Equality Act or kicked them out of the club and effectively handed to them on a plate a victimisation claim. So it's a slightly different way of putting a discrimination claim, which can be a bit easier for a claimant, and those in charge of clubs and so on need to be aware of that.
Yeah, no, that's a very good point, and thanks for raising that, Colin. It is definitely that there are few fewer hoops for a claimant to jump through if they have a claim of victimisation. Because as Colin says, the original complaint might not have stood up as a standalone claim, but if they are treated badly because of it, then they might well have a relatively straightforward victimisation claim. Yes, that's definitely something that the service providers have to be very well aware of. Moving on to Section 15 of the Equality Act, this is something of a standalone section along with the reasonable adjustments provisions, because this is specific to disability. So discrimination because of something arising from disability is where unfavourable treatment occurs, not because of disability itself, which would be direct discrimination, but because of something that arises from disability. So that could well be a symptom of a particular condition. If someone is treated unfavourably because of that, then that would be discrimination because of something arising from disability. So, for example, a neurodivergent individual might well qualify as a disabled person under Section 6 of the Equality Act. It might not be that someone treats them badly or unfavourably, to use the statutory language, because they are a neurodivergent person, but it might cause something like a difficulty understanding tone. It might cause something like a difficulty understanding when it's their turn to speak. If someone were to treat that individual badly because of that, that could well be a claim under Section 15 of the Equality Act. Although it can be justified as a proportionate means of achieving a legitimate aim. But specifically regarding provision of services, again, it's the same prohibitions that we saw for victimisation. The discrimination in providing the service might include the terms of the provision of the service, terminating the provision of the service. But also any other detriment because of that something arising from disability. Finally, the provisions about reasonable adjustments. I know that Patrick is going to talk a little bit about this, but the simplest form of a reasonable adjustments claim is where there is a PCP, so again that provision, criterion or practice, that puts an individual with a disability at a substantial disadvantage. So not a particular disadvantage at this time, but a substantial one. Those providing services and exercising public functions do have a duty to make reasonable adjustments. That applies to both service providers and individuals exercising a public function. Contained within that section is, of course, the word reasonable. So the adjustments that are required depend on the circumstances and what is possible for the service provider to provide. But for example, if we think about exercise of a public function, if an individual were imprisoned and they had a disability, they might require an adapted cell. But if they were placed in an ordinary cell, that could be a failure to make reasonable adjustments on the part of someone exercising a public function, and that could well be a good reasonable adjustments claim. So I'm now going to hand over to Patrick to take you through some of the specifics of non-employment discrimination.
Thank you very much, Tamsin. So now we're up to speed on the way that the Equality Act applies to employment law. I'm going to go through a few of the ways in which the Equality Act applies to other people and specific and other situations, specifically these four parts here. It won't surprise you probably to learn that Part 3, provision of services, Tamsin's already touched on it, will take up the majority of the talk because realistically most businesses offer a service of some sort, and therefore almost all of the case law in this area is caught within Part 3, so I'll be talking about that. There are some other parts that apply. Part 4 is premises, Part 6 education, Part 7 associations, I'll be touching on as well, and essentially looking at some of the differences between these and part 5, which is the employment part, saying that the same sort of general principles apply, but there are some nuances to how the principles work, and I'll be mentioning a couple of cases along the way. The first of these then is part 3, provision of services and public functions, and this obviously affects anybody who's offering goods, facilities or services to the public or a section of it. So it covers a wide range of people: banks, transport operators. A lot of them, the case law you might have heard of, concerns retailers. As Tamsin's already mentioned, also covers the public functions. A lot of us in chambers deal with public authorities and represent government departments, for example, and public functions is any activity carried out by a public authority, which tends not to be carried out by a private authority, so revenue collection, law enforcement, and so on and so forth. Anybody who does work in the public sector will be aware of the public sector equality duty, of course, which is an entirely different thing, probably an entirely different talk. And as Tamsin's already mentioned, the part 3 doesn't apply to marriage and civil partnership. It does apply to age, but not to people under the age of 18. Core duties, obviously very similar to employment law. In employment law, you don't discriminate against somebody on the basis of the whether they're able to be employed, or the termination of that employment, or other detriments in the meantime. And under part 3, exactly the same sort of thing, discriminating in terms of providing a service, terminating a service, or any other detriment. And again, discrimination, harassment and victimisation all apply. There's some complexity about how the different provisions apply, particularly in reasonable adjustments. And I've given an example here. It's easy to forget that about 2/3 of the Equality Act is made up of schedules which affect the various things that came before it. And one of them is this: under part 3, all 3 of the different requirements apply under the duty to make reasonable adjustments. So the first one is the PCP provision, criterion or practice that we've talked about. The second is where a physical feature puts a disabled person at a substantial disadvantage. And the third is where an auxiliary aid or lack of puts a disabled person at a substantial disadvantage. So employment lawyers are very, very familiar with this. But what Schedule 2 to the Equality Act does is it amends the words like this. Rather than having to, in order to invoke the duty, rather than there being a disabled person at a substantial disadvantage, there's now disabled persons generally. And that has 2 effects. The first is they now have class disadvantage. And employment lawyers are familiar with this from section 19, the indirect claims. But that is a separate part of the test if you want to make a claim for reasonable adjustments, failure to make reasonable adjustments under part 3. And the second thing that it does is makes it an anticipatory duty, which I think is probably harder, because where you're an employer, for example, you're talking about an individual. You know who they are, you can ask them about how their disability affects them and any adjustments you can make. In fact, you should be doing so. But for a service provider, it is an anticipatory duty, and you have to make sure that you are thinking about any particular individual with any particular disability and what substantial disadvantage might be caused to them in the future. The other way that it is changed, the duty to make reasonable adjustments, is the second requirement in terms of physical feature. What Schedule 2 does to that is it changes it in 2 different ways. The first is the same as before. Now it's disabled persons generally, so we have an anticipatory duty. The second is to give the alternative, where you can't avoid the disadvantage, then you can adopt a reasonable alternative method of providing the service or exercising the function.
Just before you go on there, Patrick, I wonder if because we're looking at the world at large for service providers rather than individual employees, the safety valve in that respect might be in terms of the reasonableness of adjustments required.
Yes.
Not least because if you're looking at the world at large, there'll be a vast number of hidden disabilities. And you're placing quite a burden on the service providers to think of absolutely every potential disadvantage that needs alleviating for every potential disability that might be out there, overt or otherwise. So I wonder whether there's a different approach to the reasonableness of an adjustment that might apply in provision of services as opposed to under the employment provisions.
I think it all comes down to proportionality. I'll be mentioning that in one of the cases that comes up. But you're absolutely right. You can't anticipate absolutely everything. Sometimes I wonder if law is just one giant reasonableness test. If they were reasonable in absolutely everything. But yes, no, you're absolutely right. And I was going to go on and talk about the case of Lee and Ash's baking, which a lot of us will be very familiar with, not least because it hit the papers back in 2018 when it reached the Supreme Court. And this was a man, Mr. Lee, a gay man who went to a cake shop in Belfast and asked for this cake. It was that specific image. He asked how on a cake. This was ultimately made by a different bakery for reasons which will become clear. But the bakery, Ash's Baking, initially said, yes, we can do that. And then they had a chat amongst themselves and said, you know what, that doesn't align with our values, with our Christian values. And therefore, we are going to cancel the order. And they issued with a refund. And that was found at first instance to be a breach of section 13. That's what Tamsin was talking about in terms of direct discrimination, being treated less favourably by reason of his sexuality. And this reached the Supreme Court. He was awarded the grand total of £500, incidentally, at first instance. And then by the time it got to the Supreme Court, they said, no, it wasn't because of his sexuality, because the question they asked was, would a gay customer ordering a neutral cake have been refused? And they found on those particular facts that no, he could have ordered any other cake, pretty much apart from that one, and they would have cheerfully made it for him. So it wasn't because of his sexuality, it was because of the message of the cake, and the company shouldn't have been compelled to promote a message with which they didn't disagree. And it's a difficult one because a lot of the time the message can be indissociable from the person themselves. But in this case, on those particular facts, the Supreme Court said that that was not discrimination for those reasons. There's another case with which you will probably be at least passingly familiar, and that's the one of First Group and Pauly. This was a man who was in a wheelchair, went to get onto a bus, and the wheelchair space was taken up by a lady who had a pushchair with her, and in the pushchair there was a sleeping toddler. And he asked first her, I think, and then the driver if this lady could move so that he could put his wheelchair on the bus, as there wasn't any other space for it. And there was a sign that said, please give up this space for a wheelchair user. And what the driver did was to politely request of the lady that she fold up her pushchair and vacate the space. And she said, I gather, no, it doesn't fold. And that was the end of the matter. And Mr. Pauly had to wait for the next bus. And he made a claim for failure to make reasonable adjustments, for failing to provide transport services. The recorder of first instance actually found the PCP, the policy, was a first come, first served policy, and then that a driver would simply request that someone move and take it no further. That, applying the rubric from section 13, put wheelchair users at a substantial disadvantage. There are two things they could or should have done, one of which is update the sign to say that to compel people to move for a wheelchair user, and secondly, they should have enforced the message and ultimately required the lady to vacate the bus if necessary, and awarded £5,500. Court of Appeal completely reversed that and said they wouldn't expect the driver to enforce this every single time, and the Supreme Court, by a majority, found a sort of middle ground. The sign was sufficient, but a policy to just ask wasn't sufficient. And this is where we talk about proportionality and exactly what should be expected. They Supreme Court said, we don't think you should always have to vacate the wheelchair space. It's going to be very much context dependent. They did suggest that what he could have done if the bus was ahead of schedule and there was somewhere else for the lady to sit, they could have the bus could have pulled in and essentially tried to shame this lady into moving and vacating the wheelchair space. But they overturned the Court of Appeals judgment on that basis. The sting in the tail for Mr. Pawley is that by majority, the Supreme Court also decided not to award him any damages because the recorder of first instance hadn't considered whether or not in those particular circumstances the bus driver trying to compel the lady to move from the wheelchair space would have made any difference, and therefore they weren't sure there was any damages, any loss to Mr. Pawley in any event. So that's provision of services and public functions. There's also, of course, the part of premises, and this covers pretty much anybody who is letting out or disposing of property. This naturally applies to local authorities, housing authorities, also private landlords. This doesn't apply to marriage and civil partnership either. It also doesn't apply to age at all. There's an exception for premises which are generally for the purpose of short stays by individuals who live elsewhere, so it doesn't apply to holiday lets as far as I can see. They've also messed about again with the duty to make reasonable adjustments because they have removed the second requirement, which is the requirement to where there is a physical feature of a property that might put a substantial person, or persons at large I suppose, at a substantial disadvantage. So that doesn't apply at all. And of course, public sector landlords also have the equality duty that I mentioned earlier, where they need to consider that in decisions on repairs, allocations, policy making, and so on and so forth. I had a case actually on the premises part, which was a lady whose mobility scooter was blocking a fire exit and she had been threatened with eviction. And there was a question about whether or not they failed to make reasonable adjustments. She thought that they ought to have been found somewhere else, changed the building essentially in order to store her mobility scooter elsewhere. And of course, the second requirement in terms of physical features of buildings doesn't apply, so she wasn't going to succeed on that. I don't think it was issued in the end. There were also questions of proportionality as to whether or not threatening somebody with eviction was proportionate to what they were trying to achieve. Part 6 is education, and of course this covers schools, universities. The organisation which has to comply is the responsible body for whether it's school, university, academy, higher, further education. Doesn't apply to marriage or civil partnership or age, and the core duty is very similar to under employment law and the other sections, but in admission to the university, expulsion from the university or school, and access to benefits, facilities and services in the meantime. I've mentioned extensions because here the victimisation claim, I completely agree with Colin, it's it's a powerful claim, I think, for a claimant, and often a difficult one for a respondent to face down as a claim of victimisation. Because it doesn't require any particular protected characteristics, and that's often what a party is focusing on. And actually, if they have, for example, treated somebody less favourably or subjected them to detriment on the basis that they have done some sort of protected act, then that is a difficult one to face down. The extension here is that the protected act can be done not only by the pupil themselves or the student themselves, but also by a sibling or parent of theirs. So the parent says, listen, I think you're discriminating against my child, and then they treat the child worse on that basis. That also can found a claim for victimisation. Finally, associations. And the reason that this part exists is that if you have a selection process to admit members, then it's been held that, technically speaking, Part 3 doesn't apply because you're not offering a section to the public or a section of the public. It's more of a private arrangement. So Part 7 plugs that gap. And as you might expect, given the reason it came about, this applies to associations which have some sort of membership criteria, and there's some sort of decision has to be made as to whether or not to allow somebody to join. They also have to have over 25 members. But if, for example, you only have to pay a fee to get in, so for example, a gym or a nightclub or something which you want to be a member of, that probably doesn't apply. That'll apply under Section 3 because they're providing a service like everybody else. But Section 7, where there are membership criteria, golf clubs tend to come up. And then this part of the Act would cover the person someone who's seeking to become a member, someone who's already a member, associates of theirs, and of course guests who want to attend the club. Likewise, marriage and civil partnership doesn't apply to associations. The last thing I wanted to talk to you about was the case of Ali and Reason and Not. And this is a case, you may have seen it in the news last year, in the Green Party. Dr. Ali, he was the party's Home Affairs spokesperson for a number of years, and then he was the spokesperson for policing and domestic safety, and he held gender-critical beliefs broadly. I think the judge at first instance described them as a bundle of beliefs that the biological sex is immutable and the woman has 2 X chromosomes and that sort of thing. He sued the Green Party under Part 7. And he sued the reason that Reason and Not are there is that Elizabeth Reason was the chair and Mr. Not was the treasurer of the Green Party Executive Committee. And he claimed direct discrimination and victimisation on about 20 different grounds, I think. Many of them were that he'd been accused of being transphobic, which he said he was not, but his main complaint was that he'd been removed as a spokesperson without any real sort of process. And apart from anything else, they could have suspended him if they actually had issues with him, he said. And they didn't. They moved to remove him entirely. Now, since Forstater, you may be aware of the European case. Gender-critical beliefs are a protected belief, as long as they're genuinely held. This isn't the forum for going into a religion or belief discussion about what sort of beliefs are protected and what are not. But he did genuinely hold this belief. It was a protected belief, and His Honour Judge Hellman, this was in the county court, dismissed the majority of his claims. Some were out of time, some were dismissed on the merits, but upheld his claim on the narrow ground that the process of removing the spokesperson was procedurally unfair. And I understand that he was the first person to succeed in bringing a Part 7 claim. And that brings us to the end. So that's just a brief look at various other ways other than employment law that that the Equality Act applies. And I'll now pass on to Colin, as I've run a little bit over, to talk about the procedure.
Thanks, Patrick. It's useful having that backdrop in terms of the substantive law. What I'm going to deal with now is how to bring these claims in the county courts where they have to be brought. And again, appreciating that we're talking here to a cohort of litigators, some of whom are more familiar with the employment tribunal practices, and some of whom are more familiar with the way the county court works. So I'll be comparing and contrasting to some extent the way matters are dealt with in the different courts and tribunals, but also pointing out specific legislation that applies to these types of cases. The first issue to consider is in respect of jurisdiction, and I'm referring continually to county court claims. You may wonder why I want to talk about high court claims. You might think that if a case is sufficiently valuable or complicated or a matter of public importance, then you may justify going to the High Court to bring it. Well, you can try, you can start there, but the Equality Act part of that claim is liable to be sent back to the county court for determination, because as a result of the statutory provisions I set out on this slide, it's the county court, or in Scotland, the sheriff, that has jurisdiction to hear the sorts of claims that Patrick has been highlighting. And the case that sets out how to deal with this is another case involving a political party. It's the case of Taylor and Evans, a case about the Labour Party, another relatively recent one. That was the case that springboarded off the back of the report into anti-Semitism in the Labour Party that you may remember was prepared around the time when Jeremy Corbyn was removed and the current Prime Minister was installed as the leader of that party. The report into anti-Semitism was leaked to the press, and a large number of those who were named in it brought claims against various persons in the Labour Party in respect of breach of confidence and data protection, but also Equality Act type claims. So one of these compendium claims, it was issued in the High Court, ostensibly on the grounds of complexity and public importance. Also, there's a lot of money at stake, but I'm not sure how the matter's concluded, indeed if it has concluded yet, and whether the claimed amounts were correctly in issue. But it came before a master in the High Court for case management, and a number of different options for dealing with the Equality Act claim were discussed, but the master sent the Equality Act part of the claim back to the county court, retaining the more significant parts in the High Court, and gave some very complex case management directions. The master rejected all sorts of procedural tricks to try and keep matters all together, convening as a county court judge, and so on. He explicitly referred to the fact the statutory scheme set out there allocates these matters to the county court, and wasn't prepared to go behind that. So, as I said, you may start in the High Court, but if it's an Equality Act claim, you're likely to be transferred down to the county court. Of course, in many of the district registries around the country, Birmingham included, it won't really matter in terms of the judges you get, because most of the judges sitting in the county court have Section 9 or deputy tickets, and the judges that hear the claim ultimately anyway. So it may not make as much of a difference in the local district registries as it does in the central registry in London. The next issue to flag to you is limitation and time limits. This is obviously one of the more important points, and county court litigators amongst you will be used to the luxury of the more leisurely 3 or 6 year time limits for personal injury tort claims or tort contract claims. You've got to join the Employment Litigators Club, I'm afraid, and get on with things, although you do have a slightly more generous 6-month time limit in these matters in the county court as opposed to your 3-month employment tribunal time limit. Subject to extensions on a just and equitable basis, a term that we're well familiar to all employment lawyers amongst you, a term of art that's developed some case law attached to the employment tribunal, but for those just versed in county court and civil matters, it's a similar discretion to the Section 33 Limitation Act personal injury limitation extension, discretion to extend time. There is, however, separate case law that you need to consider very carefully if you are bringing claims out of time. There's also the continuing act principles, set them out on the slide there, again, sort of thing that employment lawyers will be familiar with. They're often relevant in discrimination claims because they tend to involve complaints about continuing states of affairs. Failures to make adjustments aren't necessarily one-off acts, but take place over a period of time. Also discriminatory policies or practices which don't really have a set start or end date often, such as exclusions from premises or exclusions from clubs. There are, again, cases that deal with this in the Equality Act, and no reason to suspect that the tribunal case law wouldn't be readily citable to the county court if the limitation issue arose. But be aware and bring your claim within 6 months of the last of any series of acts that you complain of, so as to be have a confident argument that it's in time. When does the clock stop, though? This is something that is slightly different in county court and civil litigation to employment litigation. Those in employment tribunals will be familiar with the date on the ET1 as being the date, the relevant date, and subject to extensions for ACAS early conciliation, which I'll talk about in just a moment. But in the county court, there are several potential different dates in play for limitation purposes. You've got the date that you send the claim form to the court, you've got the date or the county court bulk issue centre or the civil national business centre, whichever one you have to utilise at the particular time. You've got maybe the date that it's deemed served at that place pursuant to the service provisions of the civil procedure rules. It could be the date that the claim form is actually received by the court, or it could be the date that the court actually gets around to looking at the post, processing the matter, putting a stamp on it, and the issue date, which is what you'll find on the notice of issue that ultimately comes out. The CPR is quite clear on this. The practice direction that I set out on the slide is applicable. It's the date that's received by the court. The claim is brought for the purposes of Limitation Act calculations. That, of course, doesn't explicitly refer to the Equality Act provisions. It refers to the Limitation Act, but I suspect cross-reading, that would be, there'd be the argument that that's the relevant date for those purposes. The lesson here is to keep a very careful date of everything that you do and do everything in good time. Don't leave it to the last minute. That's always a good idea because you may be out of time by a day and you can't necessarily guarantee that the just and equitable extension can be utilised to get your case on in time. I'll come back to that topic in just a moment. Before I do that, I'll talk about pre-action steps. This might seem a bit backwards, but you'll see why I've done it in just a moment. Of course, those in the employment tribunal are familiar with the ACAS early conciliation process, where it's a prerequisite for taking proceedings in the employment tribunal that you have to have put a notification to ACAS and receive the certificate so that you can cite the number when you unsuccessfully attempt to resolve the case and go into the tribunal. There's no compulsory pre-action ADR process in county court civil litigation. Your claim won't be rejected or not accepted, as it might be in the tribunal for not undertaking ADR. But a failure to do so can be taken into account at a later stage when dealing with issues such as costs. If you just issue and serve without notifying the other side you're intending to do so, you may find yourself at the wrong end of a cost order, even if you win. Again, something I'll touch on later on. But the expectation is that in these Equality Act claims, that the general practice direction on pre-action protocol is adhered to. And that gives an expectation on the part of a claimant, or a potential claimant, to put a letter of claim to the potential defendant, setting out what the claim's about, how much it's worth and what the claimant wants. The defendant then has time to respond within a reasonable time, at least 14 days up to 3 months. The aim is to facilitate early exchange of information. The defendant's also expected to apply disclosure, which in a discrimination claim may be of great assistance. There's the potential for you to apply for pre-action disclosure if you're not satisfied with the documents that have been supplied. But that's a whole other seminar and something that we can obviously help with if you think it might be of assistance. The interesting difference that I find practicing in both the county court and the employment tribunal is that in the county court you quite often get admissions and you quite often get offers before we go into litigation. It's probably a consequence of the fact that the costs liability that might adhere to a failure to successfully defend a claim. And some defendants might just make a nuisance offer. We don't accept, but without prejudice, take this money and go away, because that places the defendant in a good position if later on the claimant succeeds and fails to do better in terms of compensation than the amount that was offered. Because unlike in the employment tribunal, that's a pretty good ground to get the costs awarded in your favour and could make the whole claim a bit of a non-entity if the claimant doesn't successfully recover an amount to cover the cost order they've got to pay to the defendant for having brought the litigation. So there's certainly a lot more going on pre-action in my experience in the civil claims than in the employment tribunal discrimination claims. So it's important that you are aware of the need to deal with pre-action protocol. But of course, that does bring you up against these strict time limits, and it may be you're instructed late, you've not got the time to go through proper pre-action processes before you put the claim into court. Now, you've got to get the claim in time. So what can you do? There are a few things that you can consider doing. I've put forward them on the slide there. You can issue the claim and then serve it, but apply to stay it. That's certainly what the practice direction suggests you might think about doing. You could issue the claim and use the 4-month validity of the claim form for service to buy yourself a bit more time. You could make an application to court to extend the time for service after you've issued the claim, or you could agree with the other side a limitation standstill, not to take the point on limitation in subsequent litigation. This is an area that is full of bear traps and so on for the unwary, and it's often, if you're unfamiliar with the way these provisions work, it's often worth just picking up the phone to someone who does know about it and asking, what should I do here? Because getting this wrong can be fatal, and there are multiple instances in the authorities of people trying to rescue situations having taken the wrong approach. We can help on that. If you are struggling, if you've got a time limit, get some input, come up with a strategy, and we, as I say, we can assist on that sort of thing. Because if you get the date wrong and your claim is struck out as a result of a limitation defence, it's a cast iron or a professional negligence claim for the claimant. So it's worth getting this right. Moving then to what happens when you take the claim into the court process. Via your claim form. You need to be aware of the practice direction on proceedings under enactments related to equality, which is specifically in relation to these sort of cases. Have a read of it. You've got to give notice to the Equality and Human Rights Commission of having brought a claim, and it's a mandatory requirement, must give notice, but it has no teeth really, because you can't have costs or any other sanction ordered against you if you don't do it. If you've not done it by the time you get to court and see a judge for case management, you may well be ordered to do it. And the EHCR might get in, EHRC, forgive me, might get involved and take on the litigation. There's a question mark over how their costs will be paid, but it's very rare they do get involved, other than in matters of public importance. In your normal day-to-day practice, your notification was likely to go unanswered. Also, when you take matters into the court system by the claim form, you're going to want to set out what remedy you want. There are 3 main remedies. The Equality Act grants the county court the power to grant any remedy, which could be granted by the High Court in cases of this type. Damages being the primary remedy, damages for injury to feelings, not personal injury, which those practicing in the employment tribunal will be well aware of. They can include aggravated and exemplary damages. I've set out the case law on the slide. And personal injury damages for specific psychiatric injury, diagnosable as such, caused by the discrimination. They are recoverable. Of course, there might be other personal injuries and disability discrimination claims, exacerbation of an underlying condition, for example, but you're going to need medical evidence. And the practice direction to Part 16 requires you to serve the medical evidence with your particulars of claim. So don't forget that. You might be ordered to rectify that if you haven't got a medical report from an independent professional on which you rely to secure those damages. Injunctions and declarations are also available. Injunctions on an interim or final basis. Interim injunctions to compel readmission to premises or a club, that sort of thing, again, that we can help with if you need an urgent turnaround on these things. Good working knowledge of your local county court judges and clerking systems is vital, and those in chambers dealing with this sort of matter can assist you on that. When we get into the court system, we get the particulars of claim and claim form served, defence comes back denied. We then get allocated to a court track. 4 court tracks now: small claims fast track, intermediate and multi-track. Likelihood is you're getting a fast or multi-track allocation for cases like this, depending on the value. Small claims not generally where they get allocated, although if it is a small claim for damages, you might end up there. There are some costs, consequences of that. As a claimant, you get cost protection in small claims court. You're not going to end up paying defendant costs if you lose necessarily, unless you behave unreasonably. But on the fast track, there are set fixed costs. The multi-track costs are at large and they get budgeted by the court. So you generally spend a bit more money, but also be liable for a bit more money should you lose. The differences are in relation to the sorts of directions given, the trial listing, duration, and the level of judiciary that will be dealing with the trial. The other notable difference to standard county court practice is that the county court claims on the Equality Act require the appointment of an assessor. The Equality Act says that that's mandatory under section 114(7). The discretion to appoint an assessor must be exercised unless the judge is satisfied there are good reasons for not doing so. I've sent out there a really useful document for those litigating these kind of claims, the Equality and Human Rights Commission Code of Practice on Services, Public Functions and Associations. That suggests that the court couldn't dispense with the need for an assessor just because it thinks it can deal with it without an assessor, or that having an assessor would lengthen the proceedings. So arguments is don't cost too much or take too long, don't wash, it would seem. But quite often we see these sort of claims proceeding without assessors. It's a provision that the courts sometimes don't have drawn to their attention the need to appoint an assessor to deal with these kind of cases. That guidance there will assist you if you want an assessor. And generally, I recommend reading that guidance if you are bringing one of these claims or responding to one. The directions ought to have provision for CVs to be provided and for the parties to agree upon the identity of the assessor. The court provides the assessor. You're asking me what is an assessor, I'm sure. It's a bit like the employment tribunals where you have a lay member. They're a sort of a cross between an expert witness and a lay member. They assist the judge. They can assist with the evaluation of the evidence. Or they can actually give evidence. This gives rise to some questions of what are the parties to do about an assessor? Does the assessor provide a report? Do the parties know what the assessor's told the judge and have the chance to challenge it prior to judgment being given? The case I've cited there, Laidley, a case from quite relatively recently, 2025, deals with these issues. It identifies that if the assessor is acting as essentially an expert witness to provide evidence, then normally that will be shared with the parties, so they'll have the chance to address it. But if the assessor is more like a lay tribunal member and is assisting the judge on matters that the judge has to make decisions on by reference to their experience and so on, it might be a bit of a fine distinction here, I know, but this is the way the case says. If it's an evaluative role the assessor's taking, their evidence is not normally disclosed unless fairness demands it. So you'll have a judge and potentially someone else dealing with this case. And finally, I'll touch on some differences in terms of costs and funding. Employment tribunal lawyers, costs are a rarity except in exceptional cases and reasonable conduct. But unless you're on the small claims track, costs follow the event, and ordinarily the loser pays the winner's costs, reasonable costs to be assessed. Standard basis of costs, if it's a normal run litigation, indemnity costs can be ordered for bad behaviour. Depending on your track, you may have fixed costs. There are fixed costs in play in the fast and intermediate tracks. These claims are unlikely to go to an intermediate track if you're after an injunction, but I suppose there's a possibility if the damage is only claim, it might end up there. If you're on the multi-track, costs are budgeted and set by the court at a separate hearing, and the court will set the parameters for recovery. Of course, if you win but don't better an offer that's made, that can displace the costs follow the event principle. And let's say a claimant wins £500 but was offered to go away for £1,000 at a very early stage, then all the costs the claimant's incurred since that offer expired are not recoverable, and there is the potential for the defendant to get their own costs from that date, which can render the whole litigation pointless. So offers can displace usual principles. And the final thing I'll flag to you is qualified one-way cost shifting. This is a special sort of cost protection that applies in county court claims relevant to personal injury matters. A personal injury claimant does enjoy cost protection. Now, in some of these Equality Act claims, you're going to have a personal injury element, and that makes it a mixed claim. what's called. You've got a mix of personal injury and non-personal injury issues. In these sort of claims, there's case law that can be utilised to secure some costs protection for a claimant, so they're not at the mercy of the defendant should they lose in terms of these claims. But it's not absolute, and the thrust of the case law is that it might be a proportion of the case costs that's protected, the PI element, but that the costs of the rest of the claim might still be at large, so a losing claimant might face a cost bill. This, in my experience, is the thing that claimants, when they come asking to bring Quality Act claims, don't generally appreciate, and that employment lawyers don't fully advise on this risk of ending up footing the bill should the claim go pear-shaped, because it's not as at the forefront of our minds when we litigate employment tribunal matters as it is when we litigate in civil matters. So again, something, if you're not sure about, we can help. We can put you in touch with the right provisions and give the advice necessary for a client in those circumstances. And again, I've flagged that if it's a PI claim, you need to put a medical report in to give it that extra evidence upon which the case can be brought, to avoid falling foul of the practice direction to Part 16 that requires you to do that. So that's a whistle-stop tour of the differences and some of the similarities. I hope you found that useful. Yes, thank you very much for your time this morning. We will be circulating the slides afterwards if you need them. As I mentioned, you know where we are if you need any assistance. We look forward to hearing from you. Bye.
Thanks everyone, bye.
Thank you.